given the nature of these charges, the defendant's prior record involving alcohol, and his 0.18 at the time of this alleged incident. And so the court will set the cash component in the amount of $15,000 cash surety.
Court does call the case of People versus Gary Carmichael.
This is the Public Defender Natalie Pate with and on behalf of Mr. Carmichael, who stands to my right. Please state your name for the record, sir.
Gary Walter Carmichael.
Excuse me one moment. I don't have the motion.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Today's hearing involves serious domestic violence allegations, alcohol abuse concerns, and a judge forced to decide whether a defendant should remain free or face a significant cash bond. At the center of the case is Gary Carmichael, accused of violently assaulting the mother of his child after allegedly drinking heavily. The prosecution claims strangulation, physical assault, and a history of troubling behavior, while the defense argues the current bond conditions are already strict enough. But here's the real question. Was the original bond too lenient for charges this serious? Let's break down exactly what happened inside this courtroom.
All right. This is the people's motion. They're just bringing the paperwork. This is the people's emergency motion regarding bond.
Yes, Your Honor. Just to start, the defendant was arraigned on January 3rd and was given a PR bond with GPS tether alcohol tether by our $25,000 surety bond, a GPS tether, and an alcohol tether. The events in this case stem from an incident between the defendant and his partner and the mother of their 2-year-old child. On that day, the defendant had been drinking, and the victim described that he consumed a pint of liquor and 2 tall boy alcohol beverages before this incident. And initially, they had a verbal dispute that escalated into physical violence. And in that, the defendant originally took the victim's phone and threw it against the wall. He then proceeded to go to his gun safe and start digging around in his gun safe. Then he returned to the victim, charged at her while she was on the couch, and held her on the couch and proceeded to strangle her. The victim described the defendant trying to strangle her 4 times and ultimately punching her in the face. She also reported to officers that there had been multiple incidents that involved domestic violence that she never reported, including an incident where he picked her up by the throat and threw her against the wall. During this incident, she was pregnant at the time. I also concerned officers noticed injuries consistent with her statements, including strangulation marks, a busted lip, and blood on her shirt, as well as furniture being out of place in the residence, table being turned over. At the time of this assault as well, there was a child asleep in the home. So I have concerns for her safety, the community's safety, and I believe that the original bond as set was an abuse of discretion, given that he, in his previous criminal history, does have convictions related to drinking. So I would have concerns that he was not given an alcohol tether. I would ask that for the court to send his bond at our $25,000 surety bond with the GPS tether as well as an alcohol tether, given the seriousness of it.
Let's pause here for a moment, because what the prosecutor just described is extremely serious. Allegations of strangulation during a domestic violence incident immediately raise red flags in courtrooms across the country. Why? Because legally, strangulation is considered a high-risk indicator for future lethal violence in domestic abuse cases. Add alcohol consumption, prior drinking-related convictions, and the presence of a child in the home, and suddenly the stakes get much higher. The prosecution is essentially arguing that the original bond was dangerously lenient. The defense, however, is trying to show the judge that strict monitoring, like GPS and alcohol testing, can control the risk without locking him up. So now the judge has to answer a critical question. Is supervision enough, or is jail the safer option for everyone involved?
This case and the charges the defendant is facing.
Ms. Bay.
Thank you, Your Honor. Ultimately, we are asking that the court keep the monetary about the same, being a PR bond. I do want to note that my client has had the GPS tether placed on him, and he does have no objection to an alcohol monitoring device of any kind being added as a condition of bond. Further, if the court would also like any sort of drug or alcohol testing apart from a scram or soberlink tether, my client would also be willing to do that as well. To my understanding, since the time of his arraignment and now, again, only being a couple of days, nothing has changed, and I do not believe there is any sort of bond violation or contact the complaining witness alleged since his arraignment or, quite frankly, his arrest. My client does have an address in Northville where he stays with his 2 children that are not with the complaining witness. His kids are ages 10 and 14. I do have this address in Northville. The complaining witness does not live there. He completely understands the conditions of bond of no contact and no go-to. It is my understanding the complaining witness lives in South Lyon, far away from this Northville address, and that she resides with their 2-year-old.
Define far away.
Not within the same block or neighborhood or anything like that. Obviously, it's within the same state. Northville being far or a distance from South Lyon. It is further my understanding.
They're actually relatively close at points.
I'm not going to go anywhere near.
Well,
the rest
I'm
of
just
it.
trying to figure out the distance between the two because,
It's like probably 10 miles.
yeah, relatively close. All right, go ahead.
So 10 miles or a completely different city away from where he would live. He does not live with the complaining witness. We do acknowledge they do have the 2-year-old child in common. It is my client's understanding that that 2-year-old child is now staying with the complaining witness at that South Lyon address with the complaining witness and her mother. He completely understands the need for no contact order. He states to me he's willing to do anything in order to stay out of custody. He does have full-time work at a construction company. I won't put the name of the company on the record, but he does do that in home remodeling, and he's been there about 6 or 7 years. To my understanding, this is his only pending criminal matter of any kind. Further to my understanding, at the time of this alleged offense, he was not on probation, parole, or bond in any other matter. To my understanding, his most recent prior conviction was a 2013 drinking driving conviction, so about 12 or 13 years ago at this point. Ms. Anderson from our office has been able to speak to my client's sister directly and was able to confirm where the kids are currently staying with their mother. Again, his GPS tether is
his kids.
yes, his 2 children are currently staying with their mother, who is not the complaining witness. Again, he is not asking for any contact at this time. I won't comment on the actual allegations of the case itself, given I haven't even had the opportunity to review a police report or anything of that nature. But I will note that my client does deny these accusations and states that there is a lot going on. He does understand his bond conditions, especially the no contact, no go-to order, and he understands that, quite frankly, if there's any sort of whiff of bond violation or contact or text or anything, he would be right back in custody, and he does not want to do that. And this is his only pending matter, Your Honor. So we would ask that bond remains the same. Of course, he has no objection to an added condition of the scram tether or soberlink.
Well, how does he plan on, to the extent he does, caring for the 2-year-old or his participation in that?
So usually I have full custody of my 2-year-old because of her situation that she's going through. She has a mental illness and has been in and out of rehab multiple.
See, hold on a moment. I don't know that you want to go there.
Me?
If I may, Your Honor, my client indicates to me that typically the 2-year-old does reside with him at his Northville address. His older 2 children is not in common with the complaining witness, and they reside with him. Their 2-year-old child often does reside with my client as well full-time. At the time of this offense, the 3 of them were together, and it is his understanding that the 2-year-old is still with the complaining witness right now. Initially, he was wanting to request third-party contact so he can still have contact with the 2-year-old, but at that stage, he understands if the court would not be comfortable with that.
Yes.
So I guess this allegedly occurred at her residence?
My residence.
Okay. Do you have firearms there?
Yes. I have old, like, hand-me-down, like, broken BB guns from when my dad passed away.
Yeah, BB guns in a gun case?
Yes, Your Honor. And I was able to speak to Miss Apple, who was his attorney at arraignment, and who he understands as a condition of bond, if and when released, he would have to turn those over to the, well, Northville Police Department or the Sheriff's Department, whatever would be closest to his
Are they
address.
just BB, or I shouldn't say just, but are they BB guns or we got something else?
My client is indicating just that, Your Honor.
How many?
3, and then like 4, that's like, it's in pieces. They were like from like the 30s and forward. They're just from when my dad passed away in 06.
Well, since it was brought up, and at least in terms of the motion brought up in argument, the nature of the altercation was because of the pregnancy? Is that?
If I just have one moment, Your Honor. They started, in the report, it mentions they started to have a conversation about life in the future, and that's when everything took place.
Got it. There's only one alcohol-related offense? Or does he have more?
There was one conviction from 2017 for an operating while intoxicated. There was a conviction for a dismissed operating while intoxicated from 2016, a 2014 reckless driving conviction, and then a 2013 conviction for operating minor with any VAC.
And the 2013 one was the only one I was aware of, Your Honor, and it sounds like the 2016 one was dismissed.
So we have a more a closer one to today's day of an operating while intoxicated, right?
Correct, Your Honor. That's from 3/30/2017 out of the 1483 District Court. They did a preliminary breath test in this case, and I believe it was at a 0.189.
If I may, Your Honor, my client has zero objection to any sort of alcohol, scram, or sober like being added.
Anything.
Anything else from either side?
Nothing additional, Your Honor.
What I'm gonna do in this case is how large is this gun safe that you have?
How large is my gun safe? Like, it's really mostly for paperwork. It's not big at all.
So would you say it's 2 feet, 1 feet?
Yeah, probably like 2 feet by 3 feet.
Is it an actual gun safe or is it something else?
It's an actual gun safe. Well, it's more of like a lock container, like a locker with a pin code on it.
Was there medical treatment that needed to be provided to the victim?
Per the report, she refused to seek medical treatment from the incident, but had the injuries the officers observed that we mentioned before.
Given everything that I've heard in this case, first thing that I'm going to do is I'm going to order that the defendant, prior to his release, also be placed on a scram monitoring system. Okay. With reference to in reviewing all of the other terms, I would indicate that the terms as listed are appropriate. There is certainly an objection to the monetary amount. At this time, I would then change the monetary amount, and I do find that given all of the circumstances, the court does believe it to have been an abuse of discretion to set the bond at a personal recognizance, given the nature of these charges, the defendant's prior record involving alcohol, and is 0.18 at the time of this alleged incident. And so the court will set the cash component in the amount of $15,000 cash surety. All right. So I'm adding Heather, and it's a $15,000 cash surety.
Thank you, Your Honor.
Thank you. You got it.
Do you want a blue one?
This is a felony. We probably should have one. The people versus DeJure Bond Sanders.
Alexander on behalf of the people.
And Assistant Public Defender Natalie Pate, on behalf of Mr. Bond Sanders, stands to my right. Please state your name for the record, sir.
DeJure Bond Sanders.
Thank you, Your Honor. We're here to get today on 3 separate cases, 2 of them that are scheduled for violation of probation hearing. I was able to discuss the alleged violations with Mr. Bond Sanders as to both cases. We do acknowledge that there are those new pending cases. As to the actual conduct itself, we are not going to be admitting to, of course, the underlying criminal conduct, but we do understand that those cases are pending and would respectfully request that the court consider adopting that admission and adopting the recommendation as to both cases.
You're talking, so that we're clear, on case 240803 and 250933.
Yes, Your Honor.
Ms. Blair, did you have something you wanted to say?
Your Honor, just that Mr. Bond Sanders is before the court for 2 probation cases for violations of probation. He does have 3 new pending cases, 2 of which being felonies, all involving the same victim. And there's alleged use of assaultive, threatening, or intimidating behavior on those dates, and an alleged violation of the no non-consensual contact order with the victim in this case. Other than that, Your Honor, the recommendation as to both cases is the same, that his probation be revoked, 93 days in jail with credit for 81 days that he served to date, that he served the balance, and waiving remaining terms except his financial obligations and discharging probation without proof.
I will accept the defendant's admissions for violations, of course not recognizing he's not admitting to the underlying factual elements regarding the charges, but there are other behaviors. Is there anything you want to say before I impose that?
I'm sorry.
On each of these cases, I'm going to revoke the defendant's probation. On each case, I will sentence him to 93 days in jail. Credit 81 days served, the balance, or credit 81 served. Defendant is to serve the balance. I will also, on each case, waive remaining terms except financial obligations, discharge him from probation without a plea. And on the remaining case.
Yes, Your Honor. On the remaining case, the 2511892,
Yes.
that was set for today for a bond violation hearing. The case itself is already set for jury final settlement conference in February. Given the fact that this alleged bond violation has then, gave way to new cases, we are asking if the court would consider adjourning this bond violation to the final settlement conference date or a day prior to that.
All right, so I guess.
The people would have no objection, Your Honor. I was also going to ask for an adjournment today as our officer in charge was in the hospital as recently as last night with pneumonia, so.
Okay. Well, then what I'll do is I'll adjourn the bond violation hearing to a special time on February 6th, 2026. I'll make that at 9:30, just so we separate it out from the other hearings. All right.
Thank you.
On this matter, we'll continue as revoked. Thank you.
Oh, Your Honor, sorry, I completely forgot something. Mr. Bond Sanders, when I met with him earlier today, made me aware that he believed his phone privileges are revoked. I didn't at least have a note in my files as to these 3 cases that they had been revoked. And I didn't know if Your Honor had any information as to that. I could also then try reaching out to the jail as well. Sorry about that.
Yes, on case 25933,
Oh, okay.
I had revoked his phone privileges as far back as July of 2025 on that case. And then looks, I don't see it in the other one. That was the other case I had revoked it back in July.
Your Honor, with that information, I do have a request. I would ask if the court would consider reinstating his phone privileges. To my understanding, obviously that happened back in July prior to his current remand. I did have a conversation with him again this morning. He understands the no contact order. He is asking largely so that he can have contact with his daughter. She does have some health issues. That's not the sole reason why he wants to have contact, but he's asking if the court would consider reinstating his phone privileges at this time.
Any response from people?
Your Honor, I haven't seen any violations of the no contact order through jail call, so I would just leave it to the court's discretion.
All right. That, go ahead, you want to say something?
Yeah, I just want to say, a 4-year-old daughter has epilepsy seizures, and my mother is also dealing with heart issues too. She's just been in the hospital just this past Christmas. I just want to at least be able to reach out to them to.
This hearing ultimately came down to risk versus supervision. After hearing the allegations, reviewing the defendant's alcohol-related history, and considering the seriousness of the domestic violence claims, the judge ruled that the original personal recognizance bond was too lenient. Instead, the court imposed a $15,000 cash bond along with scram alcohol monitoring, ensuring that if the defendant is released, he will be under strict supervision and unable to consume alcohol. In the second case, involving Daron Bond Sanders, the court revoked probation due to new pending charges and ordered a 93-day jail sentence with credit for time served, while addressing issues like phone privileges and upcoming hearings. Cases like these highlight how courts balance public safety, victims' protection, and defendants' rights, a difficult line judges must walk every single day. But now, we want to hear from you. Do you think the judge made the right call increasing the bond, or should strict monitoring have been enough? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
At least get everything going.
Since I only revoked it on that one case, by its own terms, once he finishes that sentence, they should be reinstated. If it's not, then the court will inform the jail of that. Follow that?
Yes.
So in about 10 days, you'll,
Okay, 10 days.
well, thereabouts, maybe 12.
Okay, I'm fine with that.
All right.
Yes, thank you.
Thank you, Your Honor.
If it doesn't happen, Brown Sanders, if it doesn't happen, let your attorney know so they can get through to me.
Okay, I will. Thank you so much.
Thank you.